Welcome to the debate. You know, when we think of a nation's borders, we almost always picture this thick, solid line drawn on a map.
Right, like a physical barrier.
Yeah, exactly. You step across that line and immediately you're subject to a totally new reality. It implies that citizenship is, just a GPS coordinate. You are physically standing on the soil, therefore you belong.
But the question is citizenship really just about where you're physically located, or is it a deeply rooted social contract based on where your ultimate loyalty actually lies?
Which is the big question. It's the tension between physical geography and political allegiance.
Exactly. And for centuries, that tension has just been quietly simmering right beneath the surface of American constitutional law.
Well, today, June 30th, 2026, that tension just boiled over. The Supreme Court handed down a monumental decision in Trump versus Barbara, and it proves that the rules defining exactly who belongs within our borders are, frankly, fiercely contested.
It really does. In a 6-3 decision, the court struck down Executive Order 14160, preserving automatic birthright citizenship for the children of undocumented immigrants and temporary visa holders.
And at the heart of this ruling is this profound intellectual clash. You've got the majority's reliance on a common law, soil-based view, which is known as jus soli, versus the dissenting originalist perspective that demands a domicile-based exclusive political allegiance. If you enjoy content like this, please take a moment to like, subscribe, follow, and turn on notifications so you'll always know when new content is released. As a quick update, we continue to monitor the Martin Stevens v. OpenAI matter. It is important to note that this is still not a lawsuit. Martin Stevens has suspended his voluntary quiet period after OpenAI filed its confidential S-1 registration statement on June 8, 2026, without first engaging with him despite having nearly a month since his final notice and more than a year since his initial notifications. Stevens views OpenAI's decision to proceed without any direct interaction as a sign of extreme disrespect. As a result, he has stated that he will not re-enter a quiet period unless it is part of a formal agreement. At the time of this recording, no settlement discussions or negotiations have been publicly confirmed. We can also report that the dead man switch has not been activated, meaning Martin Stevens remains safe from both a physical and legal standpoint. We will provide updates if circumstances change. Okay, so setting OpenAI aside for now, let's get back to that thick black line on the map. Because today, the Supreme Court basically had to decide what that line actually means when a child is born on U.S. soil to parents who are legally tied to another country.
Right. And it all hinges on 14 highly debated words in the 14th Amendment Citizenship Clause, which states all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens.
And that phrase, subject to the jurisdiction thereof, is basically the entire battleground here.
It is. Does it confer citizenship based purely on territorial birth, like simply being on the soil? Or does it require a deeper, exclusive political allegiance based on the parent's permanent domicile?
Well, I represent the majority's common law soil-based approach in this debate, arguing that territorial presence and being subject to American laws cement birthright citizenship.
And I represent the originalist, domicile-based approach, arguing that constitutional citizenship requires complete political allegiance that temporary or undocumented visitors simply do not possess.
Let's start with how Chief Justice Roberts constructed the majority's view today because, well, you really cannot understand this ruling without understanding how the framers viewed history.
History is everything here. Yeah.
Right. The 14th Amendment didn't just invent a new concept of citizenship out of thin air. It codified a centuries-old English common law rule called jus soli, which translates directly to right of the soil.
But we really need to define what that actually meant in practice back then, you know?
We do. If you look at Blackstone and famous English rulings like Calvin's case in the early 1600s, the mechanism of jus soli was essentially a very simple trade.
A trade of protection for loyalty.
Exactly. Anyone born within the sovereign's territory receives the sovereign's physical and legal protection. In exchange for that protection, that person owes reciprocal allegiance to the sovereign. It was deeply practical. It didn't matter if your parents were, say, just passing through on a merchant ship.
Though there were exceptions.
Yes, but the only exceptions to this rule were incredibly narrow, inter-sovereign edge cases.
You mean like the children of foreign diplomats?
Exactly. Foreign diplomats, invading armies occupying a territory, or Native American tribes who were historically treated as quasi-sovereign nations.
Right, they had their own political structures.
Yeah, so those groups weren't subject to the local laws in the same way. But temporary residents and undocumented immigrants today, they are entirely subject to U.S. laws. They can be taxed, arrested, and tried in American courts.
Sure, they face legal consequences.
Right, and because they are legally accountable to our system, their children born on U.S. soil are fundamentally subject to the jurisdiction of the United States. It's a territorial reality. The geography dictates the rules.
Well, I come at it from a different way. If we're going to look at history, we have to look at the actual political philosophy of the American founding and the Reconstruction era. We can't just default to English common law. Justices Thomas and Alito painstakingly detailed this in their dissents today.
Which was a massive part of their argument.
Oh, absolutely. You mentioned Calvin's case. Do you know what Calvin's case was actually built on? Perpetual subjecthood.
Meaning once a subject, always a subject.
Yes. It was a medieval feudal concept. It basically meant you owed perpetual service to the king simply because you happened to be born on his land, a bond that only ended when you died.
Okay, but
wait, the entire American settler ethos was a violent, deliberate break from that exact concept. American citizenship wasn't supposed to be some accident of geography. It was uniquely based on volition, on actively choosing a homeland.
And this is where the concept of domicile comes into play for the dissenters, right?
Precisely. Let's use an analogy. Think about the difference between staying at an Airbnb for a couple of weeks versus actually buying a house in a neighborhood.
Okay, I follow you.
When you're in an Airbnb, you're a temporary visitor. You follow the house rules, sure. You take out the trash, you don't play loud music, but you aren't paying the local property taxes that fund the schools, you aren't voting in the local HOA meetings, and your primary loyalty is still to your permanent home somewhere else.
Whereas buying a home,
Domicile, is buying the house. It's establishing a permanent legal home. Daniel Webster noted in the 19th century that America views its people as those who build their lives here. In 19th century law, temporary visitors were considered strangers, not subjects.
I see why you think that, but let me give you a different perspective. I understand the Airbnb versus homeownership analogy, but we are looking at the specific text the framers chose to write into the Constitution.
The text is key, yes.
right, so if the drafters of the 14th Amendment meant domicile, why didn't they use that word? Domicile was not some obscure concept. It was a well-known, widely used legal term appearing in countless statutes of the era. Yet they deliberately chose the word jurisdiction.
But jurisdiction had a very specific political meaning to them.
Did it? Because we know exactly how jurisdiction was understood in American law, thanks to Chief Justice John Marshall in the famous 1812 case Schooner Exchange. Marshall defined it territorially.
He did talk about territory, true.
He explicitly said, jurisdiction is the full and complete power of a nation within its own territories. He went on to say that private individuals who travel here for business or caprice are entirely amenable to the jurisdiction of the country.
Okay, but
Think about the mechanics of it. If an undocumented immigrant commits a crime in Texas, they are fully subject to the jurisdiction of the Texas court system. They don't get to waive a foreign passport or claim a lack of domicile to get out of a prison sentence. The physical soil dictates the jurisdiction, absolutely and completely.
See, I think you are conflating territorial jurisdiction with political jurisdiction. Following the speed limit or being subject to a local court is not the same thing as being part of the national political body.
You don't think they overlap?
Not in the way the 14th Amendment requires. Let's look at the actual text surrounding the Reconstruction era, which Justice Alito's dissent zeroes in on beautifully today. We have to talk about the 1866 Civil Rights Act.
Which everyone agrees is the direct precursor to the 14th Amendment.
Right. The 1866 Act explicitly granted citizenship to those born in the United States and not subject to a foreign power.
Okay.
Now, when the 14th Amendment was drafted just months later, it consolidated that exact requirement into the phrase subject to the jurisdiction thereof. Let's look at the mechanics of being subject to a foreign power. If an undocumented immigrant or a tourist on a temporary B1 or B2 visa gives birth here, they are still entirely legally bound to a foreign power.
Through their own citizenship, you mean?
Yes, their home country can legally conscript them into their military, they can tax them, they can recall them. Therefore, they lack the complete exclusive jurisdiction that the Citizenship Clause demands. It is about whether your ultimate undivided loyalty is to the United States. A tourist simply does not have that.
I hear you on the 1866 Act, and I admit the subject to a foreign power line is a tricky piece of the puzzle. But we can't talk about political allegiance and foreign powers without hitting a massive historical roadblock.
You're bringing up 1898?
I am. The Supreme Court already looked at this exact tension in 1898 in the landmark precedent United States v. Wong Mark.
A very specific case with very specific facts.
Let's lay out those facts for the listeners, because this is the absolute cornerstone of modern citizenship law. In Wong Mark, the Supreme Court affirmed citizenship for a child born in San Francisco to Chinese citizens. The government back then made the exact same argument you are making right now. They argued that because the parents owed political allegiance to the Emperor of China, the child was not fully subject to U.S. jurisdiction, and the Supreme Court explicitly rejected that argument.
Well, they rejected the outcome the government wanted, yes.
They ruled that the 14th Amendment was simply confirming the ancient, fundamental rule of citizenship by birth. Wong Mark cemented the idea that the children of foreign nationals are absolutely not excluded from birthright citizenship, definitively shutting down the idea that a parent's foreign allegiance dictates their newborn's constitutional status.
I'm sorry, but I just don't buy that. Let me tell you why. You were taking a very broad brush to a case that hinged on an incredibly narrow set of facts. Both Justice Thomas and Justice Alito pointed this out in their dissents today.
What facts are you focusing on?
In Wong Mark, the parents were explicitly recognized by the court as being legally domiciled in the United States.
So you're saying the 1898 court essentially read a domicile requirement into the 14th Amendment without explicitly making it the standard?
Exactly. They relied on it fundamentally to establish the parent's status. The parents in that case had made a permanent home in San Francisco. They had integrated. They were carrying on a business there.
Okay, they were residents.
Right. They weren't tourists on a 3-week vacation, and they weren't on lawful entrance bypassing the immigration system. The 1898 court's opinion repeatedly references their domicile. So to take an 1898 ruling about permanent, legally residing business owners and stretch it to cover modern-day birth tourists, people who literally fly in for the sole purpose of delivering a child to secure a passport, or individuals who cross the border unlawfully, is a massive leap in logic.
Because the framers wouldn't have anticipated those scenarios?
Exactly. Justice Kavanaugh noted this explicitly in his separate opinion today. Significant illegal immigration and organized modern birth tourism are phenomena that were entirely unknown to the framers in 1868. Wong Mark does not mandate a blanket constitutional right for scenarios the framers never could have conceived of, especially when the crucial foundational element of permanent domicile is completely missing.
That's an interesting point, though I would frame it differently. I mean, to say we must limit the application of the Constitution only to phenomena the framers directly anticipated is a dangerous game.
In what way?
Well, they didn't anticipate the internet, but the First Amendment still protects online speech. But let's elevate this beyond just the mechanics of an 1898 legal precedent. Let's look at the profound moral and structural argument found in Justice Jackson's concurrence today.
Ah, the anti-caste argument?
Yes. The Reconstruction amendments were not just technical legal adjustments about who gets to hold a passport. They were an anti-caste, anti-subordination reset for the entire nation.
Agreed on the broad purpose, certainly.
In plain English, the drafters wanted to ensure that America would never again have a permanent, legally inherited underclass. Think about how the Dred Scott decision functioned before the Civil War. Dred Scott basically said that citizenship was a blood-based, racialized standard. You inherited your lack of rights from your parents.
Right.
So if you tie a newborn baby's constitutional rights to the administrative visa status of their parents, or their parents' undocumented status, you are recreating the exact kind of inherited, bloodline-based caste system that the abolitionists fought a war to destroy.
But is it a caste system, or is it just the standard operation of national sovereignty?
It shifts us from jus soli, the right of the soil, which treats every single person born here as an absolute equal, to jus sanguinis, the right of blood. It punishes a child who has committed no crime and made no choices for the actions or the missing paperwork of their parent. That is the definition of inherited subordination.
That's a compelling argument. But have you considered the profound implications for the consent of the governed? Requiring complete political allegiance does not create a caste system. It merely defines the boundaries of the political community.
Boundaries that need to exist, sure.
Right. Every sovereign nation on Earth has the fundamental right and, frankly, the duty to determine who its citizens are.
But don't they determine that by establishing territorial borders?
Not exclusively. They determine it through a mutual social contract, extending the highest privilege of the land, constitutional citizenship, to the children of those who explicitly bypass or violate our immigration laws, degrades the very concept of precious mutual allegiance. It removes the consent of the governed from the equation.
But how? The child is born here.
Because a nation's citizens are the ones who share in its long-term burdens, who can be called upon to defend it, who are invested in its future. If someone is here temporarily or unlawfully, they haven't entered into that mutual pact. Denying their children automatic citizenship isn't about creating a subordinate caste. It is about maintaining the integrity of the social contract. You can't just forcefully opt into a community without the community's consent.
But leaving citizenship up to a subjective social contract test is exactly what the framers of the 14th Amendment were afraid of leaving in the hands of politicians.
I wouldn't say it's subjective.
Let's think about the practical mechanics of a domicile standard. If citizenship is a fluid concept based on a subjective measure of allegiance or domicile, it becomes incredibly vulnerable to political manipulation.
How so? Domicile is a standard legal test used all the time.
Yes, but applying it to birthright citizenship means you have to adjudicate the subjective intent of a parent to stay permanently at the exact moment a baby is born. How do you prove that? Does a bureaucrat sit down and review their lease agreements and tax returns before issuing a birth certificate?
Well, it could be tied to legal permanent residency.
But the beauty and the strength of the soil-based rule is its absolute objective clarity. The framers wanted a fixed, certain, and intelligible rule. During the debates over the 14th Amendment, Senator Lyman Trumbull enthusiastically declared that the law makes a citizen of the infant child of a foreigner born in this land.
Trumbull also spoke about not being subject to a foreign power, though.
True, but they wanted to put the question of citizenship forever to rest. They knew that if they allowed a domicile-based qualification, it would introduce infinite uncertainty and allow future legislatures to strip citizenship from unpopular minority groups just by redefining what domicile meant.
I wouldn't call the originalist approach uncertain. I would call it precise. And frankly, it aligns completely with how we treat state citizenship to this very day. Let's look at the mechanics of state citizenship. You are a citizen of the state where you are legally domiciled, not necessarily the state where you are born.
Okay, give me an example.
If a couple from New York takes a vacation to Florida and has a baby prematurely in a Miami hospital, that baby is a citizen of New York, not Florida.
Because the parents are domiciled in New York.
Exactly. The baby doesn't accidentally become a Floridian just because of the GPS coordinates of the delivery room. So why should national citizenship operate on a cruder, less rational metric than state citizenship?
National sovereignty is different from state lines, though.
But the historical evidence supporting this requirement of deep allegiance is substantial. Even after the 14th Amendment was ratified, the State Department routinely denied passports and citizenship to those with doubtful allegiance. Treatises by prominent scholars in the late 19th century, like Francis Wharton, emphasized that only if parents were domiciled in the U.S. was the child internationally subject to our jurisdiction.
Right, late 19th century.
Yes. The idea that everyone in 1868 understood the 14th Amendment to grant universal birthright citizenship regardless of the parent's legal status is a historical fiction. The original public meaning demanded a true, definitive severing of foreign ties.
Yet if you look at the executive branch practice leading up to the 1880s, it heavily favored the common law soil-based rule. It was really only when anti-immigrant sentiment, specifically during the Chinese exclusion era, began to peak that we saw these novel international law theories of domicile creeping into the State Department's arguments.
You think it was entirely motivated by exclusion?
I think they were looking for legal loopholes to exclude groups they found undesirable. And those were the exact arguments, I will remind you, that the Supreme Court soundly rejected in Wong Kim Ark.
They rejected the exclusion based on race, absolutely, but they relied on the parent's lawful domicile to do it. You can't separate the ruling from the facts of the case.
Fair enough, but let's synthesize where we stand in light of today's monumental decision. To summarize my position, the Supreme Court got it right in Trump v. Barber. The 14th Amendment was a sweeping, universalist promise.
A promise you believe is tied strictly to the territory.
Yes, it tied citizenship to the objective, physical reality of the soil and subjection to the laws of the land. It intentionally rejected the European models of inherited status, ensuring that America would never again feature a legally entrenched underclass of people who are born, live, and die within its borders, but are denied the right to belong.
And to synthesize my perspective, the dissents by Justices Thomas and Alito offer the far more constitutionally rigorous framework. True citizenship has never been a mere accident of geography or a GPS coordinate.
It requires more, in your view.
It requires a mutual, exclusive political allegiance and domicile. That is a concept rooted deeply in early American law, the settler ethos of choosing your community, and the specific text of the 1866 Civil Rights Act. The 14th Amendment was designed to secure rights for freed slaves who knew absolutely no other home, not to mandate citizenship for the children of foreign nationals who retain legal and political allegiance to other global powers. The majority's decision today effectively strips the political community of its right to define its own borders and its own membership.
It is absolutely fascinating, though, that despite this deep, almost unbridgeable philosophical divide on the mechanics of jurisdiction and domicile, both sides of the court today completely agree on the fundamental triumph of the Reconstruction era.
Oh, absolutely. There's total convergence on that point.
Right. If you read the majority and the dissents, both vehemently acknowledge that the 14th Amendment was a necessary, glorious victory over the dark, racist legacy of Dred Scott.
No one is arguing that the 14th Amendment didn't fundamentally transform the Constitution for the better by eradicating race-based citizenship. The disagreement simply lies in the mechanism. Did the framers intend to extend that specific triumph to the children of foreign nationals who are only temporarily or unlawfully present, or did they have a more defined political community in mind?
Exactly. The Trump v. Barber decision illustrates the enduring, powerful tension in our constitutional law. We are constantly navigating the space between interpreting the Constitution's sweeping, universalist language, the soaring rhetoric of equality, and defining the precise, practical legal bounds of national sovereignty.
It's a delicate balance.
There is so much more to explore in this material. I highly suggest our listeners dive into the rich historical sources we discussed today, from the intense debates over the 1866 Civil Rights Act to the fascinating history and specific facts of the Wong Kim Ark decision.
It really does require looking at the primary sources. When you read the treatises and the early case law, you realize the history of how we define concepts like jurisdiction and allegiance is essentially the history of the nation itself.
Which brings us right back to where we started today, that thick, solid line on the map. It turns out, when you try to map the legal reality of human citizenship onto physical geography, the borders aren't just drawn in ink.
No, they're not.
They are drawn in history, in complex political philosophy, and in an ongoing, rigorous debate over what it truly means to belong. Is it where you stand, or is it where you commit?
The line on the map might tell you where you are standing, but as the court showed today, it is the Constitution that tells you who you are.
And that is a question we will undoubtedly keep arguing about for generations to come. If you found this episode valuable, please like, subscribe, share, follow, and turn on notifications. It helps us continue bringing you content like this and ensures you never miss future releases.